What happened at the hearing in the case of the guy charged with not keeping left of the dividing line? Yes, traffic offences like this can end up at a hearing at the New South Wales Local Court. Basically, pleading not guilty to a charge will see it go to a hearing, where the prosecution is required to prove the elements of the offence beyond reasonable doubt. So it's May 2024, and there's a hearing here at Cessnock Local Court for the offence that is not keeping left of the dividing line. Police claim the P-plate driver crossed double lines to overtake. The hearing starts with the most important step. Where's the defendant driver? So the sheriff heads outside the courthouse and calls the defendant's name 3 times. Meanwhile, in the courtroom, there's some confusing discussion about the prosecution's case. I can hear the discussion, but I'm not following. Is it possible the police don't have their witness? Which is going to make it interesting to prove the elements of the offence. However, it doesn't matter because the defendant driver hasn't shown up. Police prosecutors seek the matter to be dealt with in the defendant's absence, which the law allows. See section 196 of the Criminal Procedure Act 1986, and we're in New South Wales. The magistrate reads the file and finds the offence proven. The driver is convicted and fined $440. If I could say 2 things. First, say the driver turned up. There was a possibility that the police weren't ready. If that actually was the case, then the outcome may have been quite different. Second, say the driver did turn up and was found guilty or changed their plea to guilty. I think there would have been an opportunity to then tell their side of the story, which may or may not have resulted in a different outcome. For example, a lesser fine or maybe even no fine. In my opinion, telling your side of the story can be to your benefit. However, only you can tell your side of the story at the New South Wales Local Court, which involves showing up.